Welcome. Thank you for coming to tonight's panel. We're recognizing Constitution Day today. Technically, Constitution Day is September 17th, but this is the week in which we've chosen to commemorate Constitution Day. Actually, the federal government legislated in 2004 that every institution receiving federal funds has to recognize Constitution Day in some way. So this is, I guess, political science and work that we've got one of the results of what the lawmakers do in Washington is that we are obliged to give some recognition to the Constitution. And we're fortunate tonight to have three distinguished panelists here to help us understand better the importance of the U.S. Constitution in our daily life and work. So please participate fully by giving the panelists your full attention. Take notes. There's, I know that Professor Delahanty has a form back there for you to sign in for extra credit. And I've posted on Brightspace that for you to write some reflections to receive from extra credit. So please pay close attention and write 2 to 3 sentences of reflection, or longer if you like, about what you hear tonight. And finally, I hope that you'll participate in some way. Either we have a great opportunity to have these panelists answer your questions you might have at the end. And we will also, I'm sure they'd be willing to speak to you if you want to approach them. I know some students are interested in law school, and this would be a great opportunity to meet some people with a lot of experience in that area. So I'll introduce our three panelists, and then we'll get started. Stephen Balkaran currently teaches political science here at Springfield College and at a number of institutions of higher education in Connecticut. He and I actually were in graduate school together at the University of Connecticut.
Put my age out there.
Oh, you mean you're young like me, right? And I won't say the age, but we played a little bit of softball together in graduate school, and he received his master's degree in political science. Stephen has been interviewed by local television stations and has written widely in the area of civil rights, politics, and law, so he'll talk about that tonight. In the center, we have José Santos, who is currently pursuing a master's in theological studies at Harvard University. He teaches several courses at Harvard and at Central Connecticut State University. He holds a JD, a law degree from Boston College Law School, and a master's degree in international law and diplomacy from Tufts University's Fletcher School of Law and Diplomacy. Joseph has 3 decades of proven leadership in the corporate world as well, and more than 25 years of experience having worked at United Technologies Corporation. And we have Carl Schuman, who's served as a Connecticut Superior Court judge since 1998. Give some dates now for Carl, if you don't mind.
Can't help it.
Carl holds a JD degree from Duke University Law School, which is why he was making reference to your sweatshirt. He's the editor of an 810-page work on Connecticut criminal procedure. And I think Springfield College students will also be interested to know that Carl is United States Soccer Federation certified soccer referee since 2006.
It's like being a judge.
Another form of judging. And also has run the Boston Marathon twice, completed 9 other marathons, so maybe you have some questions for him about that as well, about training for marathons, as well as several triathlons.
Studying law.
Yeah. So without further ado, I'll let Steve start us off, and then I believe we'll go from there. So Steve.
Thank you, Professor Tom. Can you guys hear me? Yes, no, maybe? Yes. I can speak up. Okay. First of all, yes, thank you for the opportunity to be here at Springfield College. I'm honored to obviously be a part of this great, I think, scholarship that we are going to obviously articulate at some point today. I think we have 3 different ideas on this great document. My class today know where I stand on this document. But I wanted to obviously just talk a little bit about my days at Quinnipiac Law School many years ago. I was always fascinated with the Constitution, not even as a law student, but as an undergrad. And I was just kind of obviously, looking at due process, 14th Amendment, the Bill of Rights, and this is really fascinating with case law, Judge Holmes and some of his decisions. So when I saw the opportunity to speak here today, I said, okay, I have to sort of get into this. When I saw there was a distinguished panel of Mr. Santos, who and I share some work at another university, and Judge Carl, who obviously a distinguished jurist, I was even more honored. So we have one judge who obviously interprets the Constitution, Attorney Santos, I guess, still practice law or don't practice law, and I teach law. So I think we have three different perspectives on this great document. So what I like to do today is a number of things. I want to look at the influence on the U.S. Constitution and the influence of slavery as an institution. You know, we talk about this great document, we all call before the law, due process, but this document played a very important role in dividing this country. And I say divide along the issue of race, racism, and even a woman said to me today, sexism. Women were never part of this document. So obviously it's a very sexist document, too, besides being a racist document. I guess we could obviously have a new Me Too movement on this Constitution. But I wanted to talk about the role of slavery. You know, I was fascinated on this, and obviously I was really interested with some of the factors that began to influence and shape and define the young and new republic. And I say young republic class because by 1787, this young nation was full immensely in hate and in racism. But what the Constitution did was okayed it. And that's taught throughout the next 50, 60, 70, 80 years with case law from the Dred Scott case, Booth going to law school, Plessy versus Ferguson, even Roberts versus the city of Boston. All these things that talk about life, liberty, pursuit of happiness, due process of law, all men are created equal. Well, is it all men, Judge? Is it all men or is it all white men? Makes it a very interesting debate. Obviously, we talk about scholarship here, and obviously race in America, civil rights, as Dr. McCarty wanted me to talk about today, and obviously how we constructed a country, as Justice Thurgood Marshall says, the two America, one white, one black, and what has changed. So I pose a philosophical question to all my students when I lecture here or law on slavery at Mount University. Is this document a pro-slavery document? What were the intent of the framers when constructing this great document? Were they want to create a good country, create a great country, or were they trying to protect their interests, protect slavery? Was it a compromise between northern states and southern states over the institution of slavery? Obviously, we don't know. We read documents and scholarship and so forth. That's always been an interesting question. Was this a compromise between northern states and southern states in 1787 over slavery? Or was it a document that shied away from the institution of slavery? And again, interestingly enough, ladies and gentlemen, the word slavery is not mentioned in any portion of the original Constitution until 1865, the 13th Amendment. Though indirectly, I'll talk about at some point in the next couple of slides, it's there, it's mentioned, it's protected, but it obviously, it's not mentioned. So what is this great document, and how do we construct or deconstruct this document? Is it a white supremacy document? Is it a racist document? Is it a document for white men? Is it a sexist document? I don't have the answers to that question, but obviously we'll have a chance to dialogue among ourselves. So as I do in many of my speeches throughout the country, I start with a quote. William Lloyd Garrison, yes, no, maybe, famous abolitionist from the great Commonwealth of Massachusetts. Well, he said regarding the U.S. Constitution, he said, this is a compact class which exists between North and South. It's a covenant with death and an agreement with hell. This document is an agreement with hell. He said, class, simply put, America is going straight to hell. That's what he said about the U.S. Constitution. How can it be so great? As Professor Margaret in law school told me, it was such a great document. Frederick Douglass, famed abolitionist. If you have not read Frederick Douglass, read his 4th of July speech, read his speech on the U.S. Constitution, see what he has to say. Abolitionist Ambassador Douglass, he was the first African American in 1880, I believe, to be nominated for a vice president by a major political party. Years ahead of Obama, years ahead. Frederick Douglass. Look what he says about the Constitution in 1787. He said, to him, your celebration is a sham. Your boasted liberty, your unholy license, your national greatness swollen in varsity, your songs of rejoicing are empty and heartless. Your denunciation of tyrants, brass, prudent imprudence, your shouts of liberty, equality, hollow mockery. Your prayers, your hymns, your sermons, and thanksgiving, with all your religious parade, are solemnly class are to him a mere bombast, fraud, deception, impiety, and hypocrisy. It's a thin veil to cover up crimes which would disgrace a nation of savages. There's not a nation on earth guilty of the practices most shocking and bloody that are the people of the United States at this very hour, referring to the United States Constitution and the Declaration of Independence. Frederick Douglass. What do you say? Two sides to the story. I always say the African American side. At least I have a chance to entertain it, you know? You don't have to agree with Douglass. When asked before the document, before they sat together in Philadelphia in 1787, James Madison, who architects this great document, when asked, you know what he said? He said, this country will never work. This country will never work because it couldn't figure what to do with slavery. This is, class, a slave document. It will never work. Thomas Jefferson, who served in France as the ambassador, he's in Paris, I believe, but yeah, as the ambassador, when asked about slavery and the Constitution, you know what he said about slavery? He said, should we get rid of it? He said, no, you're crazy. That's too good of a deal. That's what Jefferson said about his document and slavery. Slavery is too good of a deal. Why should we get rid of it? So when they got together, it was a compromise of how do we keep this institution without disturbing this young, fledgling new republic. This document is a pro-slavery document. It endorses, it okayed racism, it okayed sexism, it okayed white supremacy, as we say today, white privilege. It's an interesting document. These are some of the more famous Americans that are talking about this great document. So I start off with my next slide. Here we have the formation of America, a young nation, fledgling nation engulfed in hate, racism, white supremacy as depicted and endorsed by the United States Constitution. And we have two major political philosophy from 1787 to 1865 when it came to this document and the Republic, African American, slavery, racism, white supremacy, sexism, whatever you want to call it. And what is the philosophy? How do we keep this nation intact? The 13 states and how many states are coming on without disturbing that institution of slavery. What do we have to do? Compromises. The United States of compromises. That's what it was. All the way to 1865. How do we keep this union intact? Compromise 1820, 1850, Dred Scott case, all the way to 1877, Plessy versus Ferguson, all the way to the Brown decision. How do we get around this document and protect institution of slavery, white supremacy, hatred, ignorance, and obviously a lot of sexism? This is a bit small, so let me see if I can get a little bigger for you here. Here we are. So slavery, as I said earlier, is not mentioned in this great document. When the founding fathers got together in Philadelphia, and this is a documented history, they all shied away from this great debate. It was the elephant in the room, slavery as an institution. Ben Franklin, famed founding father, attended the convention wearing two hats. One, as the president of the Philadelphia Abolitionist Society, and two, as a delegate from the Commonwealth of Pennsylvania. Who wore two hats. Ben Franklin was asked to speak about the institution of slavery at the convention. There's no record of Ben Franklin saying anything about slavery. Ben Franklin himself had owned slaves. Though he was the president of the Abolitionist Society in Philadelphia, he shied away from this document that we all cherish. And I say that not to put the document down. God, we live in the greatest country in the world. Because when I teach my international relations class, we see emerging democracies, young countries, 1960s, out in the Caribbean and Africa, who are adopting and modeling their constitution behind our document. It's very interesting to see this thing, emerging democracies. So it's not mentioned, but we have three things, 3 or 4 things, class, that's mentioned in the document. And the first one simply is saying the 3/5 rule. If you study constitutionalism, how was our government made up? Well, northern states wanted something and southern states wanted something, and it had to do with how we count slaves. It's called the 3/5 rule. Northern states could not get their votes, and southern states couldn't get their votes, so they came to a compromise over African Americans, the 3/5, 2/5 rule, property versus people. That's how our electoral process is constructed. Southern states want to count the African Americans as people, so they had more votes, more numbers. And states said, no, say, hold on. No, you're crazy. They're property. If you own property, you pay more what? Taxes, and there's the struggle starts right there. So right off the bat, we see the 3/5, 2/5 rule, okay? Slaves are not mentioned, but we know it relates directly to African Americans and the creation of our, electoral system. The second one, the Fugitive Slave Act, 1791. Anyone escaping the South to the North must be returned back to their masters in that one context. Well, who's escaping? Are white folks leaving the South and running to the North? We know that's not true. Yes, there are white folks probably leaving. I don't get me wrong. But we know most of the people who are escaping or trying to leave the South are African Americans. But again, it's not mentioned in the document. Persons. 1808, the migration and importation of persons. There's a moratorium, and as of 1808, we are going to stop importing Africans from, obviously, the old world. Or at least we think so. But who are we importing in 1808? Who are we importing in 1780? Who are we importing in 1760? And blah, 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 going back how many years? African American slaves. So this document, though it's not mentioning slavery class, is protecting this institution in so many capacities. Thank you. Oh my God.
3 minutes.
Tom, you give me a break, bro. That's what happens when you get a professor to lecture. You know, it took 3 hours. Okay. So I have a quote here from Yale professor Dr. Akil. He said this document is a pro-slavery document. He says the framers' class embraced black inferiority and white supremacy. That's what this document created. White supremacy and black inferiority class enshrined in the power of slaveholders. James Madison, years after this document was written and signed and ratified by the 13 states some 10 years after, look what James Madison said. He said the final work class did not include slave or slavery because it was considered class the wrong to admit the Constitution was an idea that men could hold property. Men could hold property. And this idea goes back to obviously John Locke, inalienable rights. John Locke, philosophy, famous English philosopher. If you take a philosophy class with me, John Locke is like Jefferson, he's like Adams, he's like all these speakers, all these founding fathers who wrote this document. They are men of contradictions. They say one thing, but do something other. John Locke, ladies and gentlemen, was the largest investor in the Royal English Slave Trade Company. John Locke. Document, in fact. Yet he writes about all men are created equal, life, liberty, that becomes the foundation of these great documents that we're talking about. I see it, John, I see it. I see it. So here we have Plessy versus Ferguson, Roger Taney, Dred Scott case. I'm not going to give you all this case law. Justice Taney said the document, the U.S. Constitution class, African Americans are not citizens. They have no rights to which a white man was born to respect because this document was only written for white men. His words. That's what he said. Yet you have the audacity to tell me this is not a slave document. Are you serious? Justice Marshall, last quote. At the 200th anniversary of this great document, he said, it was, and I quote, was it effective from the start, requiring several amendments, the Civil War, momentous social transformation to attain a system of constitutional government and respect for individual freedoms and human rights, as we hold as fundamental today, end of quote. Last quote. Dr. Martin Luther King, the night before he was assassinated, April 3rd, 1968, in Memphis, Tennessee. And he's talking about the Constitution, probably it's a bit too small to concede. He says, class, and I quote Dr. King, all we ask Americans to be true to yourself. Practice what you preach. Practice the word of the U.S. Constitution. That's all we ask. Practice what you preach. So thank you, end of quote. Thank you guys for having me.
Thank you. Thank you. Went right on time.
Sure?
Yeah.
Don't cheat me on my time here, okay?
Right on time.
I have to go for another 2 hours, you know that.
Just to abuse.
Each one, 10 minutes.
Yeah, no, we can just do like that.
No more than 15 minutes.
No, I think I can do that.
Okay.
All right, good evening, ladies and gentlemen. My name's Carl Schuman. I'm a judge of the Superior Court in Connecticut. Professor Carty, thank you for inviting me. I want to talk about the Constitution and criminal justice. This is normally a subject that takes an entire year to teach, but professor has asked me to condense it into 15 minutes. It's a bit like putting a boulder in a teacup, but I will do my best. The Constitution plays a large role in criminal justice. But before I get to that, I just want to say that there are many other sources of rights and obligations in the criminal justice that affect the criminal justice system: state constitutions, federal statutes, and state and federal rules. We're not going to talk about those. We're going to get right to the Constitution. There are 4 amendments in the Bill of Rights, which was ratified in 1791. Am I correct, Professor? Yes. 4 amendments in the Bill of Rights that principally deal with criminal justice. Can anyone name any of them? Any one of them? Any amendment in the Bill of Rights? It's a number. Just give me a number. No, 14th is not in the Bill of Rights. The second deals with firearms, but it does not really deal with criminal justice. Sixth is one of them. Thank you. We're going to start with the fourth, however. We're going to talk about the fourth, fifth, sixth, and eighth very quickly. So I don't have my laser pointer, but we're going to start with the Fourth Amendment. And the most interesting thing is it starts with the phrase, the right of the people. The Fourth Amendment is the only amendment of the four that we're going to talk about that applies to all people, whether you're suspected of a crime or not. It applies to totally innocent people, so that if the police want to do a search of your car or your home for evidence that someone else committed a crime, whether it's someone you know or not, you are protected by the Fourth Amendment, even though you're not suspected or charged suspected of or charged with a crime. It applies to all people. There are two principal parts to the Second Amendment. The first is a clause that says people are secure in their persons against unreasonable searches and seizures. The second clause starts here, and no warrants shall issue but upon probable cause, and several other requirements. So this tells you that searches don't have to be conducted by warrant. But they do have to be reasonable. So there are a number of types of searches that you may have heard about that are warrantless searches that have been determined to be reasonable by the U.S. Supreme Court. For example, search incident to arrest, search of items in plain view, search of an automobile, search based on consent. These are all searches without a warrant, and the only requirement of the Constitution is that they not be unreasonable. Then the second part of the Fourth Amendment deals with searches upon warrants. And there are three requirements that you can read. No warrant shall issue, 1, but upon probable cause, 2, supported by oath or affirmation, police officer has to swear to the warrant, and 3, particularly describing the place to be searched and persons or things to be seized. Now I just want to focus on the last requirement of a search warrant because this has historical basis. When the founders wrote the Bill of Rights, they were repelling against the writs of assistance and general search warrants that the British had used to just search any home for any reason at all. Now a search warrant has to be particular and identify the place to be searched and the items to be seized. So those are the requirements of the Fourth Amendment. Moving along very quickly, we're going to talk about the Fifth Amendment. And we've all heard about taking the fifth. This is the basis for that phrase. It actually has three principal guarantees. The first is that no person shall be held to answer unless upon presentment of a grand jury. And a grand jury is a group usually of 18 people who just decide whether to charge people with crime, not decide whether they're guilty or not. Now, this is a very interesting guarantee because it is not incorporated. It applies to the federal government, but not to the state governments. There are several other provisions of the Constitution that have not been incorporated. So, Connecticut does not have a grand jury system, and it's not required by the federal Constitution to do so. The federal government is required. Massachusetts does have a grand jury system, although it's not required to. The next guarantee in the Fifth Amendment is what's called the Double Jeopardy Clause. We've all heard of that. Nor shall any person be subject for the same offense to be twice put in jeopardy. The Double Jeopardy Clause creates three principal guarantees. If you're convicted of a crime, you cannot be tried and convicted again for the same crime. If you're acquitted of a crime, you cannot be tried and convicted of the same crime. So once you're found not guilty of a crime, unless with some very limited exceptions, you cannot be tried again. And the third part of double jeopardy is a little more complicated, but if you've been convicted of robbery and larceny in the same trial, those are related offenses. By committing a robbery, you've necessarily committed a larceny. So you can't be punished twice for the same crime at the same trial. Now we come to the part that I referred to originally, taking the fifth. Nor shall any person be compelled to be a witness against himself. You cannot be compelled to testify if you're a criminal defendant. And a very famous case in criminal justice is based on this clause, and it provides that a person who is in custody is in an atmosphere where he or she might feel compelled to speak, and therefore he should be given certain warnings. What case am I talking about? Miranda, correct. The Miranda case requires police to give warnings to people who are arrested in custody and who are interrogated by police, because custody is a environment full of compulsion, and Miranda warnings are necessary to dispel that or redress it. We are whipping through here and going to the Sixth Amendment. The Sixth Amendment actually, ironically, has 6 guarantees, and it begins with, in all criminal prosecutions. It's unlike the Fourth Amendment, which refers to the right of the people, including completely innocent people. The Sixth Amendment refers to people who are charged with crimes. The accused shall enjoy the right to a speedy and public trial, so there are some limits to how long a person who is charged with a crime has to wait before he's put on trial, by an impartial jury of the state district. So if you're charged with a crime, assuming it's not a minor crime, you have a right to what kind of trial? A jury trial. And by an impartial jury of the state district, that has been interpreted to mean you're entitled to a jury that is selected from a fair cross-section of the community by a fair method that reaches out to all citizens of the community, regardless of whether they've registered to vote or not. And it helps guarantee that jurors are not selected in a racially biased manner as well. The next protection of the Sixth Amendment is you have a right to be informed of the nature and cause of the accusation. A grand jury indictment, or what we call an information, is a charging document that informs you of what the charges are and when the crime allegedly took place, and may contain additional information as to what the government claims you did. This is kind of a basic concept. We all believe in having a notice and opportunity to be heard. And a charging document gives you notice of what you're charged with. The next guarantee is to be confronted with the witnesses against it. This is called the Confrontation Clause, from the word confront. And the basic guarantee of the Confrontation Clause is a right to cross-examine your accusers. So if you're a defendant charged in a criminal case, you or your attorney can cross-examine police officers or victims or eyewitnesses who are testifying against you. There are other protections in the Confrontation Clause. For example, to a certain extent, it prohibits the introduction into court of reports when you don't have a chance to cross-examine the person who wrote that report. To have compulsory process, that means you can subpoena witnesses. And last but definitely not least, to have the assistance of counsel for his defense. That's a critical constitutional right that every person accused of a crime that is punishable by jail has a right to. You have the right to counsel, and as the Miranda warnings provide, if you can't afford one, the court will appoint one for you. A very famous case called Gideon versus Wainwright said that this right applies to the states as well. So it's fully incorporated into state criminal justice, unlike the grand jury right. And finally, we come to the Eighth Amendment, which is very short, has 2 guarantees. The first is that excessive bail shall not be required, and this is another kind of unusual provision of the Constitution that is not fully incorporated. States are not required to or not prohibited by the federal Constitution from imposing excessive bail, but this is an area in which states and state constitutions have expanded rights that criminal defendants might not otherwise have. In Connecticut, for example, the state constitution uses that phrase, excessive bail shall not be required. So although they're not required by the federal constitution, the state constitution prohibits excessive bail. Now we come to the probably more common aspect of the Eighth Amendment, nor cruel and unusual punishments inflicted. There are two principal areas that in today's jurisprudence in the U.S. Supreme Court these days, cruel and unusual punishment is being litigated. Can anyone name an issue that invokes the Eighth Amendment? That if you were a lawyer, you might argue this type of punishment violates the Eighth Amendment. Death penalty. So, solitary confinement is arguably a punishment. I mean, it certainly is very difficult, obviously, but it's not something that courts impose. That's up to correctional departments. We don't impose solitary confinement. In the next 10 years, we're going to see a lot more cases in the U.S. Supreme Court raising the issue of whether the death penalty per se, in and of itself, is cruel and unusual punishment. And then just the other issue on cruel and unusual punishment these days is sentencing of juveniles. So the U.S. Supreme Court has held that it violates the Eighth Amendment to sentence a juvenile to mandatory life in prison without consideration of the fact that juveniles' brains are not fully developed and there are a lot of mitigating circumstances for youths who commit crimes. So, have I used most of my time?
I'd say you have 2 minutes.
Okay. I will yield the balance of my time. I'm sure I've generated a lot of questions and hopefully you'll ask some. But that is a basic survey course of criminal justice and the Constitution in 13 minutes. Thank you for your attention.
I'm going to speak from here because if I don't, I will force myself to take an hour from you. I love this document, and I think it's one of the greatest achievements in human history. I want to do two things for you. I want to give you the fundamental basics on the Constitution as much as I can in the allotted time. And then because I come from the business world, I want to give you some of the aspects of the Constitution that relate to your future careers, because you either are going to be an employee or an employer or both. Whether you do it for a charitable institution, for the government, or for a business institution, you are going to be that in your careers. Definitions. A constitution is a declaration of values of a particular community. In this case, of a group of people who were trying to form a country out of 13 disparate groups of people that had, by that time, already hundreds of religious denominations who were at each other's throats. And by the way, all politics at that time were religious politics. There was no such thing as non-religious politics. The people who had come from England and other places in Europe, it was mostly England at the time, were trying to escape what they viewed as the tyranny or impurity of either Catholicism or Anglicanism or other established churches by that time. And they didn't like each other very much. The Constitution is the particular established values of the community at that time by a group of men who were white and who were all Protestant and who were all of the same age bracket as the four people at this table. We could probably put them into other categories as well, but those people were chosen, or in some cases chose themselves, because they were all farmers, by the way, with the exception of Benjamin Franklin. They were all farmers. They were highly educated farmers for their particular time and for their particular state. These were people who were steeped in the philosophy of ancient Greece and Rome, and in the democratic philosophy of ancient Greece in particular, and who also had studied the philosophers and thinkers of the Enlightenment. those people in France and Germany and the UK, England at the time, who had espoused their views of political philosophy, and this was the burgeoning of democracy. This was actually the first burst of democracy since ancient Athens. There had been an absence of democracy for 2,000 years. These were people who trying to free themselves and the citizens of their colonies, because they were not states until the signature of the Constitution, from what they viewed as the tyranny and oppression of a foreign power that lived very, very far away. Keep that in mind for those of you who end up in real estate. If you govern your real estate from very far away, your tenants will not end up liking you very much because they won't see you, they won't feel you, they won't feel your presence and your success. This document is in 4 sheets of paper here. It's one of the shortest political documents ever written. It is somewhere between 8 and 16 pages, depending on how you read it. I see it as one of the most successful documents ever written because 240 years later, we're still working with it. Every one of us in this room is a product of this document. And the people who wrote it were definitely a product of their age, like we are. And the people who will come after us 100 years from now are going to excoriate you and excoriate me, if they ever know me by name, for the stupidities and ignorances that we espouse today. And that is how sometimes we look at people 200 years back. It is relevant, it is appropriate to do that, but we also need to recognize that everyone is a product of their age. Fish do not know that they live in water. Has anyone here been to a small town in China? When you do, you have a much greater appreciation for the United States and for where and how we live. By the way, on the other side of that spectrum is other places in the world. It is not just that side of the spectrum. So I will compare it to other documents that I think have been extremely successive in the history of humankind. One is the Justinian Code. Has anybody heard of the Justinian Code? All right, it was the code of Roman law that the Emperor Justinian scholars went out and scoured the earth and put together a code of laws, statutes, that lived until the Philippian age, which was basically the late 1500s in Spain, when it was recodified, and then lived until the age of Napoleon, when it was recodified again, and is today still living with us as the Napoleonic Code, and is being adopted, has been adopted by Japan, is in the process of being adopted by China, and has been adopted by almost every country on the continent of Europe and in Central and South America. I'd say that's a pretty significantly successful document. It is small and it is general. Has anybody heard of the Prussian Code? Of course not. The Prussian Code was a code of laws where the Prussians tried to codify every single aspect of human behavior in over 19,000 series and tens of thousands of volumes. It was an utter failure because you cannot codify every aspect of human behavior. But when you put it in generalized terms and you establish a structure by which to interpret those terms as time changes, as culture changes, as values change, as ours has over the past 240 years, then you can have a situation in which you move from the Dred Scott decision to Plessy versus Ferguson decision, and you end up with a Brown versus Board of Education decision in 1954 that changes the prior order under the same document. And that's a beautiful thing. That's a living organism. So the structure of this document is basically a very short preamble. It has then the structure of the government in the document itself. It structures the Congress in one article, the President in another article, and the courts in another article. And then, because Thomas Jefferson was not present at the Continental Congress, he was in France, he was ambassador to France at the time, he comes back and he says, oh, you've put together a great document, but it doesn't have any rights to the people. You haven't given the people any rights. So the Bill of Rights comes on only a few years after the Constitution. The first 10 amendments are passed. And the first 10 amendments are basically, that plus the 14th Amendment, is what we as a people today view as the rights that have been given to us. Put more accurately, they are the rights. The Constitution basically says the government cannot take rights away from the people except in certain circumstances. What is not taken away, you keep. That's an important structure. And then the third part of the document is the amendments that came after the Bill of Rights. The last amendment was in 1992. It continues to be a living, breathing document. There's one aspect about the preamble that I want to quote. The first 3 words of the document is "we the people." Now, who were we the people at the time? Men, white men, Protestant white men, of the age bracket of the people at the table. And they had particular economic interests and particular other social interests, and they were primarily of the Northern and Anglican churches, and that was important to their motivations as well. But this is the first time in the history of mankind that we have a political document that puts the power in the people. Even in Athens and Rome, it didn't occur. You may see Rome, movies about Rome in which you see the letters SPQR. SPQR was the symbol of Rome in addition to the eagle and the Roman standard. It stood for Senatus Populusque Romanum, the Senate and the Roman people. That was the first time that a political document actually named people as a source of power. But it wasn't the people of Rome, it was the Senate and the Roman people. Here, it's we the people. Before this, all power rested in kings and popes and the Almighty. For the first time, the people are the source. And what does that mean? The people will be able to change governments and create new laws as their values change and as the system and as the community's politics change. So that's the preamble. And then I just want to, because I did promise to give you some clauses or some aspects of the Constitution that speak to your future careers. Of critical importance is the Commerce Clause. And the Commerce Clause basically says that Congress has the right to regulate commerce amongst the several states, except nations and Indian tribes, but the key one is amongst the several states. So what does that mean for your future businesses or your future employers? If someone is a farmer in Iowa and is farming 100 acres of wheat, and that person has no conception of where the wheat is going to end up. He farms or she farms that wheat, grows that wheat, and harvests that wheat, and bags that wheat in a farm within the borders of Iowa. Is that among the several states? It doesn't sound like it. But the Supreme Court has ruled that it does affect interstate commerce, commerce amongst the several states, and therefore Congress, the federal government, has the power to regulate the wheat that that farmer grew. So if you make a widget in Hartford, Connecticut, and you have no particular intention that it's going to cross state lines, is your widget potentially subject to federal power? Yes. And over time, the power of the federal government has grown and grown and grown. Here's another example. The federal government has the power to regulate navigable waters of the United States. If you can float a canoe on it, is it a navigable water? Yeah. If you can float this on it, is it a navigable water? Yeah. So sometimes what a community starts as its value that says, I'm only doing this to regulate ships. And as the community grows and its values change, it says, no, I want to be able to regulate pollution on a piece of water that can float this. Then those laws change according to the values. So to me, that is the great hope of this document. And by the way, it shouldn't be left, I don't believe it should be left always to the Supreme Court to make these decisions, which is where we've ended up in contemporary society. Congress basically punts to the Supreme Court because it doesn't want the accountability with the voters about passing laws that are difficult politically. And what you end up, I think where we are ending up today, is the Supreme Court making fundamental, hugely divergent decisions on matters of culture, and then the Congress criticizing the court for doing so. That, I think, is going to be a constitutional problem. So I am skeptical, I am concerned about whether this document is going to survive not the values of our country as they change, but the politics of our country as it changes over time. So far, so good. The tax and spend clause of the Constitution, is that important to us? Yeah. The power to borrow money, is that important? We're $21 trillion in debt, the federal government is. Yeah, that's kind of important. Then we come to the bill, and that's just a few. Then we come to the Bill of Rights. So you have free speech, but not all speech is free. Not all speech is protected. Yet the Constitution doesn't make any exception for free speech, but over time the courts have. That's why you can't yell fire in a theater, in a crowded theater, if there is no fire. There is the non-establishment of religion. The government of the United States cannot establish a religion as a government religion. But there is the free exercise clause, which is that even though the government doesn't establish a religion, we each are free to exercise that religion within certain constraints, which have increasingly become constrained since 1947. We can leave that for another time. The self-incrimination clause in the Fifth Amendment. And then we come to the 14th Amendment. Why the 14th Amendment was required in order to free the slaves, I still don't understand, but it was. And there is our Equal Protection Clause. Now, did the people who write the 14th Amendment in the 1860s, did they ever think in their wildest dreams that the same Equal Protection Clause was going to be used to justify gay marriage? Did they? No. But there is that living, breathing document. Equal protection freed the slaves. Yes, there was and is institutionalized racism after that. But equal protection freed the slaves. And the same Equal Protection Clause was used in a completely different context to bring greater equality to other groups of people. The Due Process Clause, which has partly been talked about. And then lastly, there's a fourth piece of the Constitution which is not in the document. And that's the right to privacy. What famous case do you know that's based on the right to privacy? Roe versus Wade. And there was a case before that in the 1960s that also was based on the right to privacy, the forerunner of Roe versus Wade, Griswold versus Connecticut. The word privacy doesn't exist in the document. But the justices, I think in a moment of brilliance, found that Thomas Jefferson came back, they didn't put it this way, I'm putting it this way. Thomas Jefferson came back and said, you've written a brilliant structure of government document, but you haven't put any rights to the people. And neither he nor everybody else thought that privacy right actually needed to be mentioned, because maybe it's just too fundamental, all right? Who should have any right to come into anybody else's bedroom, even in 1787? So the justices said, yeah, it's not explicitly there, but we find it in the shadow of the Constitution, and we're going to establish a constitutional right to privacy in Griswold versus Connecticut. It's later picked up in Roe versus Wade and has stayed as part of our jurisprudence and of our culture since that time, hopefully to stay that way. That's my spiel.
Thank you. Great. So at this moment, I'd be happy to take questions from the audience. Maybe I'll start as you're thinking. One question I wondered as you were talking, you three, how about the structure that's created? It was kind of alluded to, but the structure of the three branches of government. I think we talk about this a lot in American government class and in history class. What's the role of the structure of the separation of powers of three branches, legislative, executive, and
Well, I
judicial?
think the document itself, is founded on this principle, relationship between the federal government and the states, which is manifested obviously with federalism. The federal government and its people, the relationship through the Bill of Rights, obviously through the three branches of government. So we have what we call checks and balances, obviously, that's clearly articulated in case law. No one branch could obviously overstep its boundaries and dictate the other branch how to run yourself or even supersede your powers. So we have a clear, distinct three branches of government. Each has their own role. One makes the law, one enforces the law, one interprets the law. And their boundaries are set. So it's clearly set in case law. And can obviously, we have what we call judicial review. Most famous cases are Mara versus Madison, 1824, that clearly articulates obviously the constitutionality of laws passed by Congress, signed into law by the president, whether the law violates the Constitution or not. And if you look at even modern day, last 5 years, the Obamacare came out for judicial review, and that was the same thing that came out of that too. So it's a lot interesting to see checks and balances and how they look at case law. And that just maintains the idea of, as you said earlier, a democracy. And no one branch can dictate each other and become too powerful. Go ahead.
Just to add on to what Steve has to say, that the structure of the Constitution does separate the three branches. Article 1 is Congress, Article 2 is the President, Article 3 is the judicial power. And that's kind of the high school version, is that there are three separate branches, but the reality is that there's tremendous overlap among the branches. Just one example, judges. Federal judges have the judicial power and interpret the Constitution and other laws, but they are appointed by the President and they are confirmed by Congress. So the President and Congress have a check and balance on the judicial power, and that's an example of the overlap.
Yeah, the key word that comes to mind is what you just articulated, which is balance. And over the years, this structure has actually been likened to a three-post stool. If you have a two-post stool, it just falls over. Right? If you have a four-post stool, maybe you have more government than you need. But with a three, the table or the stool will still hold up. The key element of this, so that structure was established in the document itself. What was not established in the document itself was who gets to arbitrate when there are two branches that are not agreeing with each other with regard to what their power's at. And that was what you referred to as the Marbury versus Madison case in 1824, in which the court decided that the court, was the only governmental institution that was appropriate to have that power, and it basically gave itself that power. And Justice Marshall, and that decision has stood the test of time. It's an interesting lesson, because sometimes what we consider as law is not written law. but it's what happens by tradition over time. So that case has basically been accepted as precedent and as tradition. The British have a much deeper understanding of this because their great document is the Magna Carta. And the Magna Carta is nothing like the Constitution. It's not explicit, it's not structural, but it has been viewed over the centuries, in that case, as espousing a particular political tradition, and they continue to live by it.
Although Brexit is challenging.
Yeah, you know, that's a fascinating situation. If I can just digress for a minute, I'm often reminded of what Charles de Gaulle said about England coming into the European Union. He said England should never allow itself to come into the Union, nor should the Union allow England to come, because it will weaken Europe and divide England. And that's exactly what's happened.
Yeah.
And by the way, those were the debates that were happening in 1787. Just before the Civil War, it was the South that wanted to secede from the Union. But in 1787, the greatest danger of secession from the Union was New England.
Yes.
Right? Because New England was religiously unified, philosophically unified, whereas everybody else was not.
And southern states left based on the 10th Amendment. Powers are delegated from the states and themselves, and that's where slavery came in. Though the South never said it was slavery, so when slavery back again, it was a right to obviously be and keep slaves. But the southern states always said it was a constitutional argument they had with the with DC.
Right.
That's slavery.
Right. Because the 10th Amendment says any powers not granted to the government are reserved to the states. So, yeah, good point.
Yeah.
So from the audience, any questions? Please, go right ahead, speak up loud if you would, please.
What exactly in the Fourth Amendment is what constitutes probable cause in a search?
Judge.
You knew you were going to get that.
Well, it's a question that I can't answer with any formula, but I would just emphasize the word probable. In the case of a search warrant, are the items probably in the location that you are looking for? And are they probably evidence of a crime? For an arrest, we didn't talk about arrests, but arrests require probable cause as well. So there are two key questions to answer there. One, did a crime probably occur? And two, did the suspect probably commit it? You might ask, what do you mean, did a crime probably occur? Well, let's say police officers see two people on the street corner. One gives the second a paper bag, the second gives the first some money. That could be just the second person buying lunch. It could be a drug deal. Did it probably occur? That's what you have to decide in evaluating probable cause. But there's no more formula to it.
So, a follow-up.
Yes, sir.
Do you think that in this day and age where, according to some people, racism and racial profiling would be at an all-time high, that sort of gray area of probable cause would be a problem?
Wow.
Right.
Wow. Good question.
Well, let me ask, try to answer it, and then others may help me out here. But I think you have to distinguish between two uses of race. One is clearly improper, and that's to assume that because a person is of a particular color, he or she is more likely to have committed a crime. On the other hand, if the police have a description of a person as being black, white, or something else, race can be used as an identifying characteristic. That's not improper profile. I defer to my colleague.
Yeah, I just want to make a comment. This is an excellent question. I do a lot of diversity training for police forces in Connecticut. Not a lot anymore because I kind of out them out as racist, so they kind of cut me back. But yeah, it's funny because I think the judge made a statement. If the cops have a profile of a black man and so forth. But I often hear that argument when I speak to police and I do diversity training for them. But I kind of pose that philosophical question. Not all black people look alike. So at some point, you're racially, profiled. If we put all black people in one category, we'd all look alike, totally different. And I think there's a lot of racial profiling. And I think also they're based on statistics. Well, it's been proven that whites commit more crimes than blacks. It's been proven. You know, it might be a high percentage among African Americans, but you know, there are more crimes than whites. So we don't see white profiling. It doesn't happen in West Hartford, where I come from. So I'm not sure exactly where this police force get these ideas of whites and blacks, you know, have distinct things. It's this interesting debate.
I think it occurs. I think it occurs overall in less degree than it did, say, in the 1950s or 60s. I have, you know, my name is José, which is read as Jose, and there's a particular politics with my name. And when I've gotten stopped by a police officer in my BMW, and he looks up my name, and I think, and I'm stopped there for 20 minutes before he comes to talk to me. I think part of what's going on, and I can't prove it, I don't know, but I think part of what's going on is, why is this Jose guy driving a BMW in my town? I don't know, but the thought goes through me, right?
Profile.
Yeah.
Yeah. It happens. You know, it happened to me a couple of times, but I never made anything about it. In fact, you know, cop that stopped me was my former student at Quinnipiac. And he said, Mr. Balkaran, I'm so sorry. You know, said it goes.
Professorial privilege.
I guess so, Tom. You know.
Any other questions, please?
Yeah, go right ahead, guys.
Go ahead.
So, which Enlightenment or Greco-Roman philosopher do you think had the biggest impact on the writing of the Constitution?
Can you say that again, nice and loud?
Which Greco-Roman or Enlightenment philosopher do you think had the biggest impact on the writing?
From Enlightenment, Locke and Rousseau are, you know, traditionally thought to be the fundamental philosophers that these farmers were reading at the time. I mean, these were no ordinary farmers, right? And you know, from Roman times and Greek times, it was Aristotle and Plato and Cicero, and you know, we can see so much of Aristotle in particular reflected in the Constitution and reflected in the speeches of the founding fathers and their immediate progeny. You know, Aristotle wrote a book on ethics, and he wrote a book on politics. And his commentary on those two books were, these books are the same. Because the purpose of politics, of a political leader and of a polity, a country or a city-state, is to make an ethical life possible for its citizens. And teaching citizens ethics is the way to make good political leaders. You see how they feed on each other? And there's also, you know, a body of literature that says, and I might be doing a research paper on this soon, that good democracies, true democracies, are only possible in small states or in cities, as it was in Greece in particular. And that it starts to break down with large populations, and some might say, well, yeah, the kind of the national level political discourse in the United States might lend some credence to that. But yeah, those were the main philosophers.
What's interesting, it always, you know, in my philosophy class, I always have this argument with students because he talks about law and ethics in Aristotle. But I often wonder which politicians have any ethics, you know. And that's even in law school, I took law and ethics, and I always wonder why, because most lawyers don't have any ethics. So you lost that. We lost that somewhere at this point. But I also believe that, I think John Locke is very influential in a lot of the modern day, the age of enlightenment. You know, Jefferson studied him, wrote about him. You know, Mr. Attorney Santos talked highly of Jefferson, which I think is, you know, is commendable. But I often said he was a businessman more than an age of enlightenment guy. You know, Jefferson writes the Declaration of Independence, and he talks about freedom, Tom, and all these great things. In the morning, he's writing that document. History and documents will show you. Go to Monticello, and you'll see there. While he wrote the document in the morning, all these great things for the Declaration of Independence, in the afternoon, he's signing treasury bonds to buy and sell slaves. He's selling and buying, selling slaves in the afternoon and talking about freedom in the morning.
I'll grant him this defense even on that point, which is, unlike other people at his time, he actually wrestled with that issue. And most others were unconscious of the issue. And so, now you might say, well, he's worse because he was conscious of the issue and he did it anyway. But we go back to, he was a product of his time as well.
He writes it.
Lousy business.
He was a lousy businessman, was he?
He was always bankrupt.
Well, if you read the Notes of Virginia, have you read that text? Where he
Pretty
argued, yeah,
Pretty bad.
he argued that slavery, the delivery class, was a blessing in disguise for African Americans because they were inferior and were doing them a favor.
Yeah, it's pretty ugly language he uses about Africa.
Yeah,
So-
yeah.
So,
May I?
Yes,
may I-
please,
There,
please.
there is a comparison point to that topic, which is, we were actually importing three groups of people at the time. Was the African Americans who were coming in as slaves. There were the, what I'll call the normative Europeans. And then there were indentured servants who were white Europeans, who were coming in typically under a 7-year contract, and they were property of their white owners during that 7-year contract. They typically lived in abject conditions, often worse than the African American slaves, because African American slaves were considered property, and therefore there was a motivation for some kind of protection by their white owners, where those indentured servants were not property, so they were basically only slaves for a period of time. But that was, that too is part of the complexity of the picture of that time. Sometimes we look back 240 years and the world seems very simple to us, as we will look to somebody 100 years from now. But it was actually a very complex time.
Yeah, but you have to understand also in 1662, we left that transition, we made that transition from indentured servants to full-blown slavery. And what we did, we passed two laws in Virginia in 1662. We identified for the first time in world history, color. So now we identify black people. The Romans never had color, the Greeks never had color, the Persians never had color. So color is what became a gauge. So you could say they were poor, indentured immigrants, but the Jews became white, the Irish became white, and black people still remain black. You have to understand the concept of white supremacy and black inferiority. It goes all the way to many of my writings. That this
Also
institution.
chattels.
I'm sorry.
The introduction of chattel
Yes.
slavery, which was different than indentured servitude, and it was
Absolutely, it's
became
completely
an
different.
affluent
Two different things.
So another fascinating conversation here would be, the concept of German-based racism, English-based racism, Iberian type of racism, and French, all of which were very, very different. And I commend to you a book that goes largely into this topic, which is James Michener's book entitled Caribbean. He goes into deep detail on this in 600 pages. It's marvelous to read, and it's a wealth of information.
Well,
I think we have time for one more question. I'd love to hear from one more person from, maybe from the history class. I don't know if anybody from my history class has asked a question yet. Put you on the spot? Yeah, great. Anthony.
Hey, thank you for the lecture. My question is, what's an example of institutional slavery in the Constitution today? Do you have an example?
When we talk about the prison system, if you look at the 13th Amendment, which abolished slavery except for conditions of servitude. So the Judge Act may have a better context. But most scholars who write about race, and I read about race in 21st century to kind of narrow it down, we look at obviously the prison incarceration system. We have, African Americans incarcerated almost twice the amount of time for white, the same crimes for white to commit.
So was the question today or back then?
Today. So we use the prison industrial system. That obviously, I have a book on that, one of my last book on that. And also, education disparities, healthcare disparities, predominantly African American communities, immigration communities, gay rights, gender rights, all these things. One of my books is called Broken Promises, Broken Dreams, Civil Rights in the 21st Century. And I look at all these issues that was fought by Dr. King in the 1960s. And I look at those issues today in 2017. I wrote that book. And we actually went backwards on a lot of things. Went backwards. We have more crimes, we have more hate crimes recorded than in the 1960s in the last 10 years of this country. It's interesting, more hate crimes. And the FBI staff will show that. statistics will show that, common sense will tell you that. We have more African Americans incarcerated at one point, more than black men in college.
Could
The
be
same
because
question.
of greater sensitivity.
Well, it could be for a number of factors. It could be also racism, blatantly.
Let's have just one more comment from.
Well, I disagree somewhat with my distinguished colleague, because I don't think prisons are an example of institutional racism. I don't deny that there is racism in the criminal justice system, but I work in the system, and I can say that people who are sent, and there are wrongful convictions as well, that we have to be very careful and attentive to, but I can say that overwhelmingly people who are sent to prison deserve to go. And we bend over backwards to try to keep people out of prison, put them in programs, alternative resolutions, but when there's nothing else that works, prison is an appropriate remedy, and that I don't view it as slavery or institutional slavery. May I just add one word on a completely different note?
Sure.
We've talked a lot about the Founding Fathers. We haven't mentioned Alexander Hamilton. Although I accept the notion that the Constitution was a pro-slavery document or institutionalized slavery, is that correct?
That's perfectly fine, Judge.
I accept your point on that. Alexander Hamilton hated slavery because he saw the evils of the slave trade growing up in Nevis, St. Kitts, and St. Croix. He didn't do much about it in the Constitution or during his career, but he hated it. He hated anti-Semitism because he saw it in the Caribbean, and he hated discrimination against Native Americans, and as a result founded the Hamilton Oneida Military Academy for the education of Native Americans in New York State. So I think he was way ahead of his time.
Absolutely, Judge. Well said. He's also a Caribbean man like myself.
So I think we had a great opportunity tonight to learn a little bit more about the Constitution. We really had some great variety of perspectives here. I want to please one more time thank our panelists. And we'll be happy if you have any further questions, if you want to come up and speak to them in person. Thank you again for coming, and sign up.